Could you please give us an overview of the current status of the Artificial Inventor project?
Sure. Well, we filed for 2 patent applications for 2 things made by an AI without a traditional human inventor, at least under US UK law.
Just to start us off, could you please tell us a bit about yourself and your current work?
Sure. Well, I'm Ryan Abbott. I'm professor of law and health sciences at the University of Surrey in England and adjunct assistant professor of medicine at the David Geffen School of Medicine at UCLA. And my research focuses mainly these days on regulation of artificial intelligence.
Awesome, thank you. And in your context, what does a typical workday look like?
Varied and weird since COVID, but well, I suppose in academia, there's 3 things you're trying to do. One is teach, one is do research, and one is be of service to the community. So I teach classes and have taught classes in a number of things: intellectual property, patents, torts, healthcare regulations, AI regulations, and some other stuff. So there's teaching. I used to teach law students and other sorts of students in the US, and now I'm in England, where it's an undergraduate enterprise largely, although with some PhD students, but I think that's how you do things in Australia too.
Yeah.
And how you do your medicine training. So there's the teaching element of it. Then there's research. So I wrote a book recently, The Reasonable Robot, Artificial Intelligence and the Law, and I'm hoping I can coast on that for a while more before I have to write another book. So that was something. And I'm working on a research handbook now of AI and IP, and then a bunch of other sorts of projects. So writing those things takes a little time. And then, I'm active on a whole bunch of very boring committees, some of which are at Surrey, some of which aren't. And then, of course, litigating these Thaler cases all over the world as a service to the community, and trying to not go crazy with toddlers at home.
Yeah, sounds like a very busy schedule.
Yeah, the toddlers keep it busy, especially in COVID, but they're a lot of fun.
Yeah. Could you please give us an overview of the current status of the Artificial Inventor project?
Sure. Well, we filed for 2 patent applications for 2 things made by an AI without a traditional human inventor, at least under US UK law. And with some nuance, pretty much every country has its own patent system. So these applications, I think, went to 17 different jurisdictions. We had a patent granted in South Africa for the applications this summer, and everywhere else they are either sitting at patent offices or have been rejected by patent offices, and we are appealing the rejections in the court. Australia made news right after the South Africa patents were granted, when Justice Beach in the Federal Court of Australia issued a reasoned legal decision that there was no reason an AI couldn't be an inventor of a patent, and that, at least in our case, the person who owned the AI was the person who would own the patent, which was what we were seeking. That case was appealed by IP Australia and was just heard by a full court of 5 judges in the Federal Court of Australia. From there, it further appealed on a discretionary basis. It could go to the High Court. And it is otherwise making its way through courts in other jurisdictions. We're at the appellate court in the United States right now, after which, on a discretionary basis, it could go to the Supreme Court. The UK Court of Appeals just heard the case and upheld the Patent Office's denial of the applications, but split in doing so. So Justice Burst thought we should have gotten our patents. Justice Arnold and Lady Justice Lang didn't agree, unfortunately, but the Supreme Court's reviewing whether to take that, and so on in a few other places.
Cool, thank you. I'll pass it on to Julian now.
Yeah, it sounds like you've got a lot on, and yeah, the Reasonable Robot was a great read, by the way.
Oh, thank you.
It was really really great to talk about this AI neutral kind of position, and there wasn't much out there that really put forward the position so cleanly and succinctly. So I guess I'd like to ask a couple of questions about the Thaler case in Australia, where we're from, just because that's sort of most relevant to us in our legal studies, I think. So first of all, do you have any sort of predictions or expectations from how this will go on appeal?
You mean in Australia or everywhere?
Maybe in Australia first, but also everywhere more generally. Do you think it's inevitable that these will get accepted?
Well, it's an interesting question. Inevitable, no. So the full panel in Australia did seem a bit skeptical of the case. So we'll see how they come out. I do think that Justice Beach, his decision was absolutely correct, and he really got to the heart of the issues. And I think that in 10 years, when people have AI automating significant parts of materials discovery and, composition of matter discovery and life sciences and repurposing drugs, people are going to wonder what we were thinking back now in not protecting this sort of thing. But we aren't 10 years in the future, so I guess we'll see, and it's hard to predict the future. The UK has launched a government consultation process to see if the law should change and maybe if they will explicitly protect this sort of activity. So that's been exciting to see, right? If people want to protect this sort of thing, it may be through legislative rather than judicial processes. And part of that is, the language of patent acts differs between, say, the US, the UK, and Australia. And, if you take a step back, it's a little odd that, variations in language that no one thinks had anything to do with AI would now be governing this question of, can you protect stuff that comes out of an AI? But that's where we are. So courts interpret the statutes as they're written, with more or less purposivism. I think that's right. I'll work on that. But, more or less, taking into account what the law was intended to do and its purpose. Then also some jurisdictions will care more about this sort of thing, like China and the US, that are trying to become world leaders in AI and AI output and IP exporters. And, some other jurisdictions aren't going to have that same sort of activity and might be less inclined to protect this sort of thing.
Yeah, fantastic. And do you think there are any common misconceptions which might be guiding the inconsistent responses?
Yes, I do. Well, patent law is complicated at the best of times. And this is a particularly complicated case. And, a lot of people commenting on it who aren't patent lawyers don't understand the difference between owning something and inventing something. And so, some people have made this a case about machine rights or a machine owning a patent, which we've never argued for and which doesn't make a whole lot of sense. And it's really about incentivizing people to make, develop, and use AI that invents things, and getting businesses to disclose and commercialize the outputs of AI, which is basically, what the patent system is designed to do and protect, and to provide a socially beneficial outcome. So I think that's the biggest misconception of it. And then, these cases largely are, coming out differently due to the way people in the 50s, 60s, 70s drafted language around invention without really any thought as to this sort of thing happening. And that is sort of interesting if you think about it.
Absolutely. Yeah, and I guess this approach of allowing an artificial intelligence to become an inventor, I know you obviously think that it's a really great thing, but do you also anticipate other issues coming out of this, such as patent thickets and making the whole patent system more difficult to navigate?
Well, patent thickets, potentially, it's an interesting question. Maybe less thickets and more sort of potential consolidation. If it turns out, Dabis is, after all, operated by a small business in the Midwest of the United States. So it isn't all just, Facebook and Tencent. But if it does come to pass that really Facebook and Tencent own these AIs that just can vastly outperform human researchers, then it might be that you would have big businesses owning more IP than they do now. On the other hand, most IP is owned by businesses and a disproportionate amount by large businesses. And that's the way we've structured our economy and our, generation of IP currently. So if that is kind of the most effective way we get to things like cleaner energy sources and cures for cancer, I don't know that it's a bad thing. And if one is concerned about companies acting in anti-competitive sorts of ways, there are protections built into patent law and the law generally to address those sorts of things. So I think it's something that we need to have on our radars, but I don't think it's a good reason to slow down innovation because you're concerned that some people will have an advantage in making stuff come out of it. The AI inventorship thing, I don't think has that much impact beyond subsistence of new IP, but there are a lot of ways in which AI challenges, the generation of new works legally, commercially, and socially. For example, with copyright, AI is making copyrightable sorts of works, but also using other people's copyrightable sorts of works, and also making things like deep fakes where, we've had interactions between IP and deceptive sorts of technologies before, but this is really a new way in terms of its, ability to convincingly recreate something that we're seeing. So there are some new legal issues being raised by this that we need to give careful thought to. And it will be very disruptive, I think, when AI gets to the point where it doesn't just make new music, but makes kind of decent new music people actually want to listen to, because it could make an unlimited amount of it at no cost at that point. And, that might really impact people who aren't very good musicians right now and their ability to make a living.
Yeah, great. I had sort of one more question about the substantive effect of this, as you said. I suppose at the moment, if a person working with AI does produce an invention through the use of AI, or more realistically, the AI might produce the invention itself. At the moment, the current approach would really be to just put down the user of the AI as the inventor, using the AI as a tool, whereas what you're proposing is to recognize the AI as the inventor itself. Although the former is sort of more conceptually appealing, do you think that there will be a really substantive legal difference between the law recognizing AI as a tool versus an inventor?
Well, I'm not sure that's accurate for a few reasons. It really is very fact specific how an AI is used in an inventive process. So, someone could be, people use AI all the time. It doesn't make an AI an inventor. Someone can become an inventor by finding a problem to solve, by recognizing the value of AI output, or by, building an AI to solve a specific problem, either by, making an architecture for an AI or training it on data. And this does depend on jurisdiction, because different jurisdictions have different tests for what makes someone an inventor. But in the United States, at least, to be an inventor, you have to have conceived of an invention in your mind, and likely have exerted some inventive skill in doing that. If you have basically an off-the-shelf AI solution that can optimize problems, if you give it a known problem and commercially, publicly available data, and its output is obviously valuable, like say, I want to design a better brake pad. And, we all know what a better brake pad's characteristics would be. And here's a bunch of designs of brake pads. And it says, here's a much better brake pad. There may not be someone in that system who does qualify as an inventor. That's something, for example, that the company Siemens has been talking about and saying that they've had AI generated inventions that their engineers have not been willing to say they had invented or played a role in because they hadn't done anything inventive. So in that case, you just don't have an inventor, which means you can't get a patent under the law in the US, but not at the moment the law in Australia. Now, as a practical matter, you can just list a person and no one will question that until someone litigates a patent, in which case inventors are usually deposed. And if you were deposing someone who said, well, I just sort of put some stuff into the AI and it gave me an answer and I didn't really do anything, but the patent lawyer said, put yourself on it, then suddenly you may not have a patent anymore.
So it's sort of our concept of invention in most jurisdictions, you would say, is sort of incompatible with a sophisticated AI acting without much human input. It's incompatible with that being a tool.
Well, I mean, I suppose it depends what you mean by tool, and people do use the word tool to refer to an AI. I mean, in the sense that you're telling an AI what to do and it's not waking up and having a midlife crisis and inventing something. I mean, sure, it's a tool. On the other hand, what the AI is doing is really very similar to what a human employee does at a big drug company, right? You know, someone at Pfizer says, we need an antibody to treat COVID. And you used to have 400 pharmacologists lined up doing cell assays. And now you go to an AI and says, well, here's our target. You've got a library of 1 billion antibodies, you know, predict how they will interact with this target. And the AI says, well, here's the one that's going to work. And here's all the data you need for a patent application. And, you know, it is a tool in that it's just doing what you tell it to, but not in the sense that it is automating a certain aspect of human behavior. You know, namely, you know, what it was that made someone an inventor. So at least some of the time, you have the machine doing the thing that made a person an inventor. And I think we will have that happen much more of the time in 10 years. You know, one could say the same thing of a self-driving car. I mean, it's a tool in that it just, someone built it to take you from point A to point B, and you tell your car, take me from point A to point B. But it's also behaving the same way an Uber driver would behave in terms of taking you from point A to point B, and it's automating it so that you don't have to, you know, tell the car specifically what to do, which is why I think the term tool can be a little misleading in some of these discussions.
Yeah, absolutely. That makes sense. Yeah, so another thing I just wanted to ask is, do you have any advice for developers of AI systems or inventors about how they should respond?
I'm sorry, could you ask that question one more time?
Oh, sorry. So in light of these recent changes in our legal system around patents, do you have any advice for the developers of AI systems or for people who might be uncovering inventions through the use of them?
Sure. Well, yes, long and complicated advice. You know, it's really very fact dependent, and not everyone is building, making, and using AI because they care about patents. You know, lots of people are doing it because, I mean, not everyone's doing it for money. Some people are doing it academically, or in your case, as a student enterprise, maybe you hope to make money. Not everyone invents things because they need a patent. Some industries work pretty well without patents. It's really in some industries, particularly life sciences, where, you know, without a patent, you're probably not going to get a new drug developed because so much cost comes in after the discovery of a new composition that you really need some form of protection in place. You know, so what to do in those certain sorts of circumstances, if you can help it, it is, at this point, the way the law is to design systems so that you make sure you have at least one person who is doing something inventive, you know, but that is potentially problematic if really you do have systems that are automated and so efficient that putting a person in the loop just sort of slows things down. But it's really looking at a design, you know, an R&D process, you know, ideally at the design phase, and thinking about how this problem is going to come up in advance.
All right, great, thanks. So those, that's all of my questions. Amy, do you want to finish up?
Yeah, thanks so much for your time today. This has been really interesting, and I think for the Deep Neuron members, it'll be really valuable for them to hear this discussion.